Assalamu alaikum and welcome back to our channel, True Courtroom Stories. Today, we're diving into some incredible research from Mr. Zahir Ahmad Mir's True Courtroom Stories, episode 74. We're going to explore a legal concept that feels so completely modern. A real cornerstone of justice that we all kind of take for granted. But what if I told you its story doesn't start where you think? Today, we're talking about equality before the law and its truly surprising 19th century Ottoman origins. Seriously, think about it for a second. When you hear that phrase, equality before the law, what pops into your head? For most of us, it's probably the American Revolution or the French Revolution, right? It just feels like a bedrock principle of Western democracy. But what if a pivotal, game-changing moment for this very idea didn't happen in Paris or Philadelphia, but in Istanbul? What if a crucial seed was planted in the heart of the Ottoman Empire almost 200 years ago? It's a pretty mind-blowing thought, so let's unpack that. So, before we jump in our time machine and head back to the 1800s, let's just take a moment to ground ourselves right here, right now. We live in a world where we expect that everyone, from the person down the street to the most powerful leader in the country, is subject to the same set of laws. But if you ever stop to think what a society really looks like when that's not the case, what actually happens when power is absolute and unchecked? Well, you really end up with two completely different worlds. On one side, you have a system of arbitrary power, a world where a ruler's mood can become law overnight. Justice is inconsistent, unpredictable. One day something's fine, the next day it's a crime. And your rights? Well, they're not really rights at all. They're just privileges that can be taken away in a heartbeat. But on the other side, you have the constitutional rule of law. It's predictable, the process is clear, the law is supreme, and it applies to everyone, including the rulers themselves. And our story today is about this incredible, historic leap from the first column to the second, all happening in a place you would probably least expect. Okay, so let's go. We're heading to the 19th century Ottoman Empire. Now, you have to picture this place. It was absolutely vast, a sprawling empire with dozens of different ethnic groups, multiple religions, all living under one rule. But it was an empire facing enormous pressure, both from the outside, from powerful European nations, and from the inside. The leaders at the time, they recognized that to survive, to modernize, they just couldn't keep doing things the old way. They needed a massive, radical change. They needed a complete reorganization. And that sweeping change had a name, the Tanzimat. The word itself literally means reorganization, and believe me, they meant it. This was not about just tweaking a few laws here and there or shuffling some papers. No, this was a fundamental, top-to-bottom effort to reshape the entire empire, its military, its government administration, and, most critically for our story, its entire legal system. And a transformation this big, well, it doesn't happen with the flip of a switch. This wasn't an overnight thing. It was a long, slow, deliberate process that unfolded over several decades. It really kicks off in 1839 with this groundbreaking document that we're going to look at in just a minute. Then, through the middle of the century, they got down to the hard work of actually implementing these new ideas, building new courts, creating new administrative roles, and this whole era of reform eventually culminates in 1876 with something truly revolutionary, the empire's very first constitution. So, what exactly were they trying to do? What was the grand plan? Well, their goals were nothing short of radical for an empire of that kind in that time. First and foremost, they wanted to establish equality before the law for all subjects, not just one group, but everyone. They also wanted to build modern courts, guarantee protections for minority communities like Christians and Jews, and this is the really crucial part. They wanted to limit the absolute arbitrary power of the state itself. They were trying to put limits on their own power. In history, every huge shift seems to have a catalyst, right? A single moment, a single document where the future suddenly changes direction. For this entire Tanzimat reform movement, that moment came in the form of a special imperial edict, a declaration that would send ripples through the centuries. This landmark document was called the Hatt-i Sharif of Gülhane. It's a bit of a mouthful, but it translates to the Noble Edict of the Rose Chamber. Just picture the scene. It's 1839 in Istanbul, and this incredibly important declaration is being read aloud in public, and it contained a promise that was about to completely redefine the relationship between the government and its incredibly diverse population. And this was the line. This was the promise. All subjects of every religion shall be treated equally in the courts. Just let that sink in for a moment. In an empire that for centuries had been organized into different religious communities or millets, each with its own separate status and rules, This statement was an earthquake. It was a radical declaration that a person's faith should not determine their standing before the law. It meant that, at least in principle, a Muslim, a Christian, or a Jew would all stand as equals in court. This was so much more than a minor legal tweak. It was a fundamental reimagining of what it even meant to be a subject of the empire. So with that one powerful sentence, the Tanzimat reformers did more than just change a rule. They planted the seed for a whole new kind of state. They were paving the way for government that could manage diversity not just by passively tolerating it, but by actively protecting all communities with legally guaranteed rights. And this right here, this is the key transformation. This is where everything changes. The very source of authority began to shift. It was moving away from the absolute, unquestioned decree of the Sultan and moving toward a codified constitutional system, a system of laws that, in theory, even the Sultan himself was supposed to follow. The law was now being placed above everyone. You could almost see it like a set of dominoes falling. First, the Tanzimat Edict puts the guarantee of rights on paper for everyone. That, in turn, creates the legal foundation for pluralism, this idea that many different communities can live together as equals, all protected by the same state. And that very principle becomes a kind of blueprint, an idea that directly influences how modern, diverse nations all around the world think about justice and minority rights to this very day. Okay, I know what you might be thinking. This is a fascinating history lesson for sure, but what does it really have to do with my world today? Well, the connection is actually surprisingly direct. It's a line you can draw from the old Ottoman capital of Istanbul all the way to the supreme courts in modern capitals like Ottawa and Islamabad. Because that core idea that the Tanzimat introduced, it's a challenge that every single modern democracy is still dealing with. It's the ultimate balancing act. How do you balance the necessary power of the government with the essential freedoms of the individual? How do you make absolutely sure that the state is there to serve the people and not the other way around? And this is where we can see that legacy in the real world. Take Canada, for instance. If the government passes a law that limits a fundamental right, the courts apply something called the Oakes test to figure out if that limit is actually justified and reasonable. Now look at Pakistan. The courts there use a reasonableness standard to review government actions and make sure they're fair and not just arbitrary. These are both very sophisticated, modern legal tools, but they're designed to do exactly what the Tanzimat reformers set out to do all those years ago, put a check on executive power in order to protect the citizen. So, the crucial takeaway here is that the next time you hear people talking about the rule of law or the importance of protecting minority rights, just remember that the story is so much more complex and more global than we usually assume. The intellectual DNA of some of our most important legal protections can be traced right back to this bold reorganization that happened in the 19th century Ottoman Empire. It really makes you wonder, doesn't it? What other fundamental ideas that shape our daily lives, rights that we take for granted, might have these kinds of surprising, hidden historical roots, just waiting for us to discover them? Thank you so much for joining us for this explainer. If you found this interesting, and we hope you did, please subscribe to our channel, give this video a like.
Can spring up in different places, all on its own.
Now, this entire explainer is based on the incredible research done by Mr. Zahir Ahmad Mir in True Courtroom Stories, episode 74. His work brought this amazing parallel to light, and we're going to dive deep into the legal thinking he uncovered. It's a perfect example of how a fundamental principle of justice can emerge and really take hold, completely independently, on opposite sides of the globe.
So let's start with a really big question, something that every society has to grapple with. We all kind of accept that governments sometimes need to limit our rights for what they call the greater good, right? Think about things like public health rules or national security measures. But where do you draw the line? How do we make sure a law that's meant to help doesn't end up hurting people by going way, way too far? How do we stop a well-intentioned rule from becoming an overreach of power? This is one of the toughest challenges for any democracy.
To solve a problem like that, courts can't just go with their gut. They need a system, a structured, logical way to figure things out. And that's where this powerful legal idea comes in. It acts like a yardstick, a test to measure whether a law is truly fair or not.
That big idea is called proportionality. Now, it might sound a little academic, but the concept behind it is actually incredibly simple. It's just common sense, really. Think of it this way. You wouldn't use a giant sledgehammer to crack a tiny nut, would you? The solution has to fit the problem. In the world of law, proportionality means the same thing. A government's action has to be balanced and fitting for the issue it's trying to solve. If a law is going to step on one of your fundamental rights, that infringement better be the absolute minimum necessary to achieve its really important goal. It is all about balance. Okay, so you have this general idea of proportionality, but how do you make it a real practical tool that a judge can use in a courtroom? Well, one of the most famous and influential answers to that question actually came from Canada. They developed what's basically a blueprint for fairness. Our journey starts back in 1986 with a huge case in the Supreme Court of Canada called R.v. Oakes. Now, the case itself was about drug laws, but its impact rippled out and changed everything. The court was looking at a law that basically flipped a core legal principle on its head. It seemed to make the accused person prove their innocence instead of the other way around, innocent until proven guilty. To figure out if this major violation of rights was justified, the court needed a new framework. And so, they created one. And that framework is now famously known as the Oakes test. It's so brilliant because it breaks this huge, complicated question down into 3 straightforward but very powerful steps. First, the court asks, is the goal of this law actually important? Is it a pressing issue for society? Step 2, is there a rational connection between the restriction and the goal? In other words, does the law actually help achieve the objective? And finally, the most critical step of all, is the law proportional? Is this restriction on people's rights the most minimal, the least intrusive way to get the job done? It's just this really elegant and thorough checklist for fairness.
The Oakes test wasn't just a quick fix for one case. It became the blueprint, the go-to model for courts trying to find that delicate balance between the power of the government and the rights of the individual. It gave them a clear, transparent method for putting laws under the microscope.
But here is where our story takes a really fascinating twist. Because this powerful legal idea didn't just spread from Canada around the world. Thousands of miles away, in a totally different legal culture, an almost identical principle was developing all on its own in Pakistan.
Just look at these two side by side. On the left, you have Canada's very structured 3-step Oakes test, and on the right, you have Pakistan's reasonableness doctrine. The names are different, sure, but their job, their core function is exactly the same, using this idea of proportionality to check government power. And the amazing part is that this wasn't a case of one country copying another. This was 2 separate legal systems, independently arriving at the very same fundamental truth about what it means for a law to be fair.
Through its own unique history of court cases and its own interpretation of its constitution, Pakistan's Supreme Court forged this reasonableness doctrine. Now, unlike in Canada, where it came from one single landmark case, this doctrine in Pakistan grew more organically, over time, from a whole series of different rulings. It really reflects this deep-seated belief within the judiciary that any government action that limits a citizen's rights must itself be reasonable, it must be fair, and, above all else, it must be proportional.
But this isn't just some abstract theory that lawyers and scholars debate. This doctrine has real, tangible effects on the lives of everyday citizens. So let's take a look at where Pakistan's courts have actually put this powerful principle to work.
Okay, so this is where it gets real. Pakistani courts use this doctrine in some of the most critical areas of law. Take freedom of speech cases, for example. If the government passes a new law that restricts what journalists can report on, the court can step in and apply this test. They'll ask, is this restriction truly necessary to protect something like, say, public order? Or does it go too far and just end up silencing critics? It's used in human rights cases and to review all sorts of government actions. In every single one of these instances, the fundamental question the court is asking is this action a proportional response to the problem?
So what we have here are these 2 legal tools, the Oakes test in Canada and the reasonableness doctrine in Pakistan, both doing pretty much the same job. What's the big takeaway here? Why is this parallel so important?
In the end, this is so much more than just a cool legal coincidence. It's actually evidence of a shared, universal idea of what justice looks like. It proves that totally different societies, with their own unique histories and cultures, still recognize the exact same fundamental danger, the danger of unchecked state power. Both of these legal systems, on their own, forged a shield to protect their citizens, and that shield was built on the timeless principles of reason, balance, and proportionality. It's a perfect example of what you might call convergent evolution in the world of law.
We really hope you found this deep dive into Mr. Zahir Ahmad Mir's research as fascinating as we did. Putting these explainers together takes a lot of time and effort. So if you found this valuable, if it made you think, please do us a huge favor. Please subscribe to our channel, True Courtroom Stories, and please like this video and also share this video with your friends. Your support really helps us keep making more content just like this.
So we want to leave you with one final thought to chew on. We've seen how this idea of proportionality acts as a kind of universal safeguard for liberty. As our world gets more and more connected and the challenges we face become more global, what other fundamental principles do you think are absolutely essential for protecting citizens everywhere? What's the common ground for justice in the 21st century? Let us know what you think.
This isn't just some fancy poetic line. It's the central pillar for everything we're about to discuss. It's basically saying that a just and stable society isn't built on just one idea. It's built on the delicate, careful interplay between two powerful concepts. I like to think of it like building a stone archway. You need both sides to lean on each other perfectly. If you take away one side, the whole thing just collapses into a pile of rocks.
Okay, so if equality and proportionality are the two sides of our archway, how exactly do they hold everything together in the real world, in a courtroom? To really get that, we need to zoom in on a core legal principle that Mr. Mir puts right at the front and center. You could say it's the engine room of any court's decision. It's the how and the why of it all. So let's dive in and unpack it.
Okay, here it is, ratio decidendi. Yeah, it's a Latin term and the law is full of them, but don't let that throw you. The meaning is actually pretty straightforward, and it is absolutely crucial. It literally means the reason for the decision. See, in law, it's not enough to know what a judge decided. The most important part is why they decided it. Imagine a ruling just says, the defendant is guilty. Well, okay, but why? The ratio decidendi is the legal logic, the principle that explains how the court got from the facts to that conclusion. It's the why that sets a precedent for all future cases and separates a thoughtful, reasoned judgment from just a random command from someone in a robe.
So that begs the question, right? What makes for a good reason? What builds this crucial piece of reasoning, this ratio decidendi? How does a whole legal system come up with a why that is actually fair and just and not just arbitrary? Well, the author tells us to look right back at that opening quote we saw. He argues that the entire foundation of a just legal reason rests on those two massive pillars.
And seeing these two ideas side by side like this is really illuminating. They're like two partners in a dance. First, you have equality. This is the starting line. It says the law has to apply to everybody in the same way. It doesn't matter if you're rich or poor, what your background is, the rules are the rules for everyone. But, and this is a huge but, that's not always enough on its own. That's where proportionality steps in as a vital check. It asks, okay, is the response fitting for the situation? Is the punishment fair for the crime? It's what stops a system from, say, giving someone a life sentence for a parking ticket. It ensures moderation and common sense.
And this right here is why that partnership is so critical. Think about it. A legal system that only has equality could become incredibly cruel and rigid, right? It would apply a harsh rule to every single person without ever considering the specific context. But on the flip side, a system with only proportionality could become a total mess, completely arbitrary, with decisions changing based on a judge's mood. It's only when you bring them together, as Mr. Meyer points out, that you create a stable, predictable, and fundamentally just constitutional order. They give the system both its unshakable strength and its necessary flexibility.
Now let's build on that. We've got our foundation set with these two pillars. So what is the structure that's actually being built on top of them? Well, Mr. Mir presents this core idea about what the legal system is fundamentally for. What is its purpose? And he sees it as this constant, dynamic, and absolutely essential balancing act.
Just take a moment to let that quote sink in. It so brilliantly captures the central tension at the heart of any free and democratic society. It paints a picture of the law not just as some dusty old set of rules, but as a living, breathing referee in a constant contest. A contest between the immense power of the state on one side and the fundamental rights of the individual on the other. And look at the two contenders here. On one side, you have power. This is the government, the institutions, their ability to make laws, to enforce those laws, to maintain order. And we need that, right? Without it, you'd have chaos. But on the other side, you have rights. These are your fundamental freedoms, the things that belong to you simply because you are a person. Your right to speak, your right to be safe, your right to be treated with dignity. The entire drama of the legal system is played out in the space between these two powerful forces. It's a constant tug-of-war.
Now, this is the key moral instruction in Mr. Mir's entire argument. The balancing act isn't meant to be perfectly neutral, like a 50-50 split right down the middle. No way. The scales must be intentionally weighted. When the power of the state comes into conflict with the rights of an individual, the goal isn't just to find some lazy compromise. The goal is to find the outcome that best serves the cause of justice. In this view, power is not the goal. Power is just a tool, and its only legitimate moral use is to protect and uphold the rights of the people.
So, let's pull all these threads together now. We've talked about the foundational pillars of equality and proportionality. We've talked about this balancing act between power and rights. So, how does this all circle back and connect to that fancy legal term we started with, the ratio decidendi? This is the moment where the author's entire argument clicks beautifully into place.
This slide lays out the whole recipe perfectly. That ratio decidendi, the core reasoning of a decision, it's not just a dry technical formula. It's a moral journey. You start with those foundational principles. Is this approach fair to everyone involved? That's equality. Is the action being proposed measured and reasonable? That's proportionality. Then, you use those principles as your guide to weigh the state's power against an individual's rights. And finally, you have to conclude with the decision that tips the scales in favor of justice. That entire chain of thought, that whole moral pathway you walk to get to the answer, that is the true ratio decidendi. So, let's just boil it all down. For Mr. Mir, a legal ruling is so much more than just a simple verdict. It's a profound statement of a society's values. The reasoning behind a decision is a powerful moral commitment. It's a declaration that our system is built on fairness, that it respects the rights of every person, and that its ultimate purpose, above everything else, is to achieve justice. The why of a decision? That's its soul. And hey, if you're finding this breakdown as fascinating as I do, this would be a perfect time to please subscribe to our channel, hit that like button, and also share this video with your friends. It really helps us keep these stories coming.
And that brings us to our final and maybe most challenging thought for today. Mr. Mir's work lays out this beautiful, logical, and moral framework for how a just system should work. It's the ideal, but it leaves us with a huge question about our reality. If the entire purpose of the law is to serve justice, what happens when we encounter a law that we believe fails that test? A law that seems fundamentally unjust? What is our role then? What is the responsibility of an ordinary citizen, or a lawyer, or even a judge in that situation?